Back with you on the Newsfeed PM, and thanks for staying on. As I said, we are, of course, looking at the developments at the National Assembly. The Assembly has passed the Immigration Amendment Bill. The bill was introduced by the Minister of Home Affairs last April. The new development seeks to protect immigrants whose rights have been violated when they are in detention. Let's hear a little bit more now. I'm joined by Ashraf Essop, who is an immigration lawyer. Ashraf, good to have you. Thank you very much for coming on. Since, according to the minister, this raft of new regulations will make for swifter deportation, which means up until now, the deportation process has not been swift and, in fact, has been plagued by either court challenges or a number of delays. Take us through how the system has been and what this seeks to actually rectify.
So I think principally this amendment was forced by the Constitutional Court. You'll recall that prior to the amendment, way back in 2017, provisions of the Immigration Act made sure that people that were arrested as illegal foreigners pending deportation were kept in detention for an unspecified period. So the first thing that the court did in 2017, it said that the rights that is afforded to everyone else in the country, which is to appear in court within 48 hours of the time of arrest, should be extended to foreigners. So they shouldn't be treated differently from everyone else. Yeah. So that was the first milestone. You couldn't be held for more than 48 hours without appearing in court. Right. Now, back in those days, you could be held for up to 120 days in detention pending your deportation. Yeah. So by bringing it within 48 hours, you were afforded the right to a hearing and the right to bail. Right. Now, the recent amendments speaks of interest of justice. Now, interest of justice is a very wide concept and very, it's imbued with discretion of the judicial officer. But he basically takes a very active role in listening to evidence as to what would constitute interest of justice to be released. So, if you are released, what are the facts or what are the consequences of such release? Generally, you don't get bail if you're going to be a flight risk, which is almost impossible for foreigners because you can't leave the borders of the Republic without proper documentation, at least in theory. Yeah. And second, will you interfere with the state witnesses? And will you misbehave in between the date of your bail and the date of the hearing? Right. But let's get back to the 2017. It's a very interesting judgment by JAFTA. You see, we have to position all of these arguments within the prism of the Constitution. Now, JAFTA started by saying, in the bad old days of apartheid, you disappeared. You could be held for indefinite detention. And that was basically the reason why so many freedoms were extended to us post the Constitution, post our elections in '94. So that is the background behind these kinds of interventions. Right. Yes.
Now, does this new regulation then, therefore, now that it says you can't be detained for more than 48 hours, mean that within 48 hours you will be able to get a hearing, but to a decision on your deportation will also be made? Considering that we have other, even more pressing cases in the country that we're looking at that have not secured a day in court.
So let's just get back to the 48-hour rule. That was already put in place in 2017. All Parliament had to do was to pass legislation to match that constitutional invalidity. There, the court declared sections of the Immigration Act unlawful, being Section 34(1)(b) and D. So it's not a competition between who's in court and who doesn't get their time. Courts are extremely, extremely busy, but somehow they manage to plow through all of these things. In the event that you are denied bail, then you are remanded in the normal course for the matter to come up. However, you can force a bail application, a formal bail application. Let's say it wasn't, you were present present in court within 48 hours, but there wasn't time to deal with your bail, and bail was denied. Generally, how it works is the department then waits 7 days to get a report from immigration or inspectorate regarding your status in the country. And then they will come with the 212 statement, and then the magistrate will have to determine, based on the evidence given by the applicant or the accused and the evidence prepared under oath in terms of the affidavit, whether the interest of justice can be served in granting bail. So there's like a formal bail application. Now, part of it may be the manner in which you were arrested, or the 48 hours had expired. If the 48 hours have expired and you haven't been brought to court, you are released.
Yeah.
So there's a whole lot of considerations for the magistrate to take into account.
But Ashraf, is that not a point that could certainly be abused? Like somebody could go in and, because of just the slowness of the system, could be in for 48 hours and say, well, now it's my time to be released because I can't be held for longer than this. So you would have people that otherwise should be put in the system, deported, but being released back into wherever they come from.
That is a possibility. However, the 48-hour rule existed for a long time in our criminal justice system. The amendments just brought it back to treat everyone on the same basis. Indeed, it's rare if the 48-hour rule has not been observed, because there's a whole process there from the time that you are arrested. Let's say you're arrested on the weekend, Friday afternoon. You must appear, apart from the weekend, by Monday morning. But Monday morning, the courts are so busy that they say to you, you're appearing now, but we're rolling over till Tuesday. That's when the 48 hours expires. But you'll be surprised how courts are even sitting overtime to accommodate all of these applications so that they fall within the ambit of the law.
And what's going to then happen as far as the limitless challenges to deportations? Because the minister seems to believe that this new law will help to limit that.
Yeah, I can't really see how. What it does is it's in obeyance with the Constitutional Court ruling, giving the state or parliament time to bring legislation in line with the declaration of invalidity. Now, let's assume the minister is saying that it'll be abused. There's a legal process that one can test this kind of abuse. There's urgent court, for example. There is now mandated mediation efforts. So there's a whole lot of avenues that one can pursue in order to see that justice is served. In fact, I think engaging with the Department of Home Affairs officials together with the state attorney and their counsel yields a lot more results than just appearing in court and having your matter rolled over. So there are mechanisms in place. How the minister sees that this would streamline or make easier deportations, I think is yet to be seen. Because remember, I spoke about the interests of justice.
Yeah.
That case law will unfold over time.
So there are political parties who are of the view that actually what we need clarity on are things like what the minister says will still be discussed in the white paper, which is open for public comment: citizenship, immigration itself, and refugee protection in the country, saying there is still a lot of mud around those particular questions that need to be reviewed.
Indeed. You know, the white paper has been in place since 2017. And it's been published for a number of different, number of different times. One of the interesting things I saw in the 2017 paper, let's just talk about refugees, is the possibility of you being held in camps at the border. So you won't necessarily just be allowed to enter the Republic, apply for a refugee or asylum seeking permits, and then continue in the community at large. And I think the erstwhile Minister Motsoaledi also made that point that there were too many concessions granted in terms of the Refugees Act. So as the law unfolds and as circumstances unfold, you definitely will see more and more amendments to the Constitution to be, to the Immigrations Act, to align with the goals in the white paper. Another area that the white paper speaks about is there's no automatic conduit or expectation to get citizenship just by virtue of being married. One of the challenges that we'll face in the future is you're going to have to determine what contribution can you positively make to the Republic. Are you a rocket scientist? Are you some kind of, a business person that can create jobs and secure employment? Those would be factors taken into account from what I presently read in the white paper.
So currently, what really this achieves, according to you, Ashraf, is that this brings the act in line with what the Constitutional Court said it should be fixed as far as decisions that need to be taken on whether to detain or release an undocumented immigrant in the country. That's really all that it fixes.
That's right. And you remember there was an ex parte attempt by the erstwhile minister to get an extension of the time in which to amend legislation, and that wasn't entertained by the Constitutional Court. In fact, I think the council that was involved was deprived of his fees because the court said this is an abuse of the legal process.
Ashraf, appreciate your time. Thanks so much for coming on. That's Ashraf Essop, who is an immigration lawyer. They're bringing some analysis for us and clarity on what this immigration amendment bill really represent now that it is going to the NCOP, a step closer to heading to the president's desk that will be signed then into law. The Newsfeed PM continues for you shortly. Stay with us.